Hi, good afternoon, everyone. This is Rajiv S. Khanna from immigration.com, the law office of Rajiv S. Khanna PC. Today is April 1st, 2021. This is our bi-weekly, every 2-week community conference call. I will go over the frequently asked questions first, and then we will deal with each question that is posted in turn. I will invite your input or questions related to what I'm discussing. You can do so by pressing *5 when I get started. I'll ask you to press *5 on your phone. Okay, let's just do an audio check real quickly. Make sure you can hear me okay. So
the conference is now in conversation mode.
Can you all hear me okay, guys? Can you hear me all right? Hello.
Yes, sir. Yeah,
Thank you. Thank you.
The conference is now in presentation mode.
Let's begin with the first frequently asked question, which says, after I get my green card, is it legal to work for 2 companies and not the original company simultaneously? Well, there are actually a couple of different subcomponents to this question that you need to understand. First of all, once you have received your green card, and I wouldn't even say that a reasonable period of time has passed by, it's a little bit more complicated than that, but let's take the easy answer. Let's say you've got your green card, 6-8 months have passed by. You can do whatever you want. You can start your own business. You can work, not work, change your line of work, go back to school. You can do many, many different things. Once you've received your green card, you are free as a bird. So definitely after 6-8 months of getting your green card, you can do whatever you want. But what if you do it 6 days after you get your green card? And I think it's still okay. The reason I say that is because of the American Competitiveness in the 21st Century Act, which makes it possible for you to change jobs even before your green card is approved, your rights after the green card would be more, not less than what they were before the green card, right? So the fact that you've got your green card approval and 7 days later you moved, I don't think it should be a problem for your naturalization. I don't think it's an issue at all. However, there is one caveat, one thing to be careful about. There are 2 points in your green card process where you should have the intention to continue working with this employer who did the green card or who did your supplement J. What are those 2 points? When you first file the 485, it should be your intention to either continue working or join the employer who helped you file the 485. So at the point of filing your 485, your intention is important. And upon approval of the green card, right at the juncture, when you get your green card approval, you should have the intention to stay. Now that's a doubtful proposition, but just to be on the safe side, I would say assume that. Although if you did not and you got into trouble, I suspect you would win in court if the government tries to take away your green card. So 2 places, 2 spots in your green card process, when you actually file the 485 and when you actually receive the approval. Okay. If you had the intention to stay with this employer, but something changed. So let's say you got your green card approval today. You had no intention of leaving, but a day later you got a great offer and you changed. I think you're fine. I don't think it's a problem because the 2 points at which your intention is important, when you filed the 485, and in this case, when you got the green card approval, you had no intention of moving, right? And even if you did, I think you could argue before a court and win that that's no longer a requirement of green cards. So this whole area becomes quite unpredictable in some ways, but pretty safe for employees in most cases. I would still want you to consult with a lawyer, discuss your particular case, understand the pros and cons if you're planning to leave the job, understand what is going to happen. But I personally think it should be okay. So the question before me was, I got my green card March 2016. My project ended in May because of a change in client location. You see, this is what also protects you. You had no intention of leaving, but you're not supposed to work free for somebody. If they don't have a project, it's over. You keep your green card. Okay, and you just join 2 other jobs instead of the employer who sponsored you. I think it's okay. I personally don't see this as a problem. Will you be able to file for citizenship? Absolutely. I do believe so. The only thing I would recommend, another layer of protection. File your green card, file your naturalization 5 years after you got your green card. Okay, 5 years. You can do it 90 days earlier. Just do it 5 years, exact 5 years. That gives you an added layer of protection. Okay. *5. If anyone has a question on this, press *5, please. Okay, I have a question from area code 251. Area code 251, where are you calling from?
Hi, Rajiv. This is K12. That's my question that you just answered, and thanks for taking the question.
Which city?
Which
city are you calling from? I always like to know that.
It's Mobile, Alabama.
Okay, sir. Go ahead.
Yeah. So my case was that I got a green card in March 2016, and I continue working for the company. And the project ended at the client location because of the reorg at the client location, and the manager left, and my project also ended. Then I move on 2016 June, 3 months later,
right.
to a new location, new client.
Okay. Go ahead.
And I started working there, and my old employer.
I see. Hang on. Job, but, 1 second. You're repeating the same facts that you've written down. Why? I've already read your facts.
Now I'm like sure. Yeah, I just ended my 5-year period. So yesterday I completed the 5 years of the waiting period.
Okay, so you don't have to repeat the facts. I've already read them.
Yeah, I'll just
right. So I understand. I think you should.
So you suggest that I get a lawyer, or?
No, I don't see the need for a lawyer. Your case is straightforward. But if you feel more comfortable having a lawyer there, that's your call. I don't think this case is any more complicated than any other case, in my opinion. Just remember one thing, whatever question you are asked, answer it truthfully. Do not conceal any facts. As long as you do that, I think you should be safe. Okay?
Sure. All right. And I'm planning to wait like another couple of months so that it will give me some more bandwidth, as you said, like complete the 5-year period.
You can do another thing. Are you married?
Yeah, I am.
You can have your wife get her green card, her naturalization first, then you apply for yours.
Okay.
That gives you one more layer of protection.
All right, sure.
All right.
Thank you, Rajiv.
You're welcome.
Appreciate it.
Good luck. Okay. Let's go on to the next frequently asked question, also on AC21 Job Portability. So, IT Pro was on H1B, I-140 was approved, currently in H4, not employed, date became current. Previous employer had provided supplement J, you filed 485, 765, 131. The supplement J says you're not currently employed. That's fine. So question number 1, can I directly join a new employer after 180 days of pending I-485? In my opinion, yes, you can. You will have to file a supplement J, or you should file a supplement J again. But the law says, the way I have said this many times before, the way 180 days is counted is your I-140 is approved and 485 has been pending 180 days. So your I-140 is already approved. After 180 days, you can join any employer with the same or similar job. Can I start searching for a new job even before 180 days? Absolutely. I don't see why not. So you had some questions about final action dates and let's see. As filing date to final action date may take decades for EB3 India, if I join a new employer before 180 days and join another after 180 days, how will USCIS determine that my job change occurred prior to 180 days? Listen, don't get into all that. Bottom line is very simple. You are under oath when you go for the interview. If they ask you a question, you have to answer truthfully. If you don't, you have committed a felony, imprisonable by 5 years, up to 5 years in prison. And in addition to that, you can be permanently barred from entering the United States. So don't get into all that, how they will catch me, none of that is relevant. You are required to tell the truth. Do I have to send USCIS new supplement J? You should. once you know, this is what I advise to our clients. Once you know that you're going to stay at a job for a year or more, I think you should file a supplement J. It gives you added protection, and there's no limit to how many supplement Js you can file. Okay. What if I need to change my employer after the green card interview but before receiving green card? Listen to the discussion that I did before, just this question. We talked about how soon can I leave after getting the green card. The basic criteria are very similar. You've done the interview. Now all of a sudden you're changing jobs. I would want you to talk to your lawyer. I would not want you to take my word for it, because remember, government thinking changes with time too. Sometimes these tertiary type problems are unaddressed by the government, but they can change their position anytime. So as of now, as of today, which is April 1st, 2021, there is nothing definite about changing jobs after the interview but before the green card approval. I would suspect it is, if the job is same or similar, keep some record of it. Otherwise, you can do it. But have your lawyers follow up the procedures that exist when you actually do this. Okay. You said I have to get this is your question number 6. I have to get supplement J only from the employer with whom I'll be working at the time of green card interview. Can I send new supplement J from each employer? Absolutely. The only thing I recommend, like I said before, is that you should know that you're going to stay at that job. If you have a 3-month project, you know you're not going to stay at that job. No point in filing supplement J. But still, if you think you're close enough to getting your green card, run it by your lawyers. It's important. They should be in the loop and they should help you decide. *5 if you have a follow-up question. *5. Okay. Let's see. This one is coming from area code 770. 770, where are you calling from?
I'm calling from Atlanta.
Yes, sir. What is your question?
All right. So I posted that question. So I just have 2-3 quick questions. That right now I have already submitted my supplement from the past employers. So, but if they do not have any open position, I can directly join a company. You said that after 180 days. So my 180 days will be over soon. So what if my previous employer has got a position? Can I join them before 180 days? Who has provided the supplement J?
Absolutely. The difference between your position and somebody else's is you are not relying upon you're not relying upon the 180-day provision to join the old employer. Your old employer is the one who originally sponsored your green card. So you're not really using AC21. You are basically joining a job that was offered in the past. So I don't think you have to worry about the 180-day.
Because I'm not currently employed, so at the time of filing, I was also not employed.
That's okay. You can join them tomorrow, today, if you want.
Which means that I can join other company also before 180 days.
That's different.
My case is different.
That's different. Okay. Now, technically, you could be joining any number of companies because you are working based upon a future job. Okay. You're not working based upon a current employment. You are working based upon a future job. So if you kept switching companies in between those 180 days, I think you are reasonably safe, but I would prefer that you wait until 180 days of the 485 pendency and then start adventuring out.
Yeah, actually 180 days will be over this month, so probably I'll wait for
I don't want to debate the academics with you. If you can afford to wait 180 days, do so. End of story.
Yeah.
Okay.
Yes. Like one more thing.
I gotta go, sir. I've spent I've spent a lot of time on your question. I've got to go. Okay. Good luck.
Okay. All right. Thank you.
Yeah, guys, gotta be reasonable, okay? Because we do have limits on time, and I actually don't answer 6 questions. That's a lot of ground to cover, but I think it's important for everyone. That's why I covered it. These are the frequently asked questions. I don't think I had any more. Let me just take a quick look. Yeah, we just had 2 frequently asked questions. Now let's go back to our regular questions. This one is marked question number 4. So AOS is pending, H1B approved, and change of status is not approved. So in this case, my adjustment of status is in the pending state. H1B is approved, change of status has not been approved. Can I work in the US? Look, you can only work in the USA if you have an employment authorization. Just because the 485 is pending does not give you the right to work. You've got to have an EAD. Okay, that's a simple enough question to answer. You can stay in the United States because your 485 is pending, but you can't work until you get your EAD. Star 5, if you have a follow-up question on this, please press star 5. Okay. Next question. This is question number 5. So somebody sponsored somebody for a tourist visa. They entered on March 10th last year. They were okay to stay till September. Now here is the problem. They applied for an extension one day after their status expired. Okay, and you usually won't be given 1 full year. Extensions are limited to 6 months at one time, and this particular situation is actually quite alarming because they filed after they had fallen out of status. So the way I see it, they have been unlawfully present since September 11th. Only if their extension is approved, they might be saved from it. But if you have been unlawfully present for 180 days, you are barred from coming back for 3 years. And if you are unlawfully present for 1 year, you are barred for 10 years. Have this looked at by a lawyer. There's a problem here. Has been staying at the same physical address. You have provided financial and medical support. I think it's already an overstay because they applied 1 day too late. I don't think you're going to have a problem with your H1B just because you sponsored somebody and they broke the law, as long as you did not actively participate in the breaking of the law, smuggling of the person, something like that. I don't think you should have a problem with your visa issuance. If the question comes up, be truthful. I don't think it will, but if it comes up, be truthful. You have no control over somebody breaking the law. Star 5, if you have a follow-up question. Star 5. Okay. This is area code 608. 608, where are you calling from?
I am calling from Green Bay.
Green Bay. Where is that?
Wisconsin.
Wisconsin. Okay, sir. How can I help you?
नमस्ते राजीव जी, हम लोग पहले बात कर चुके हैं. मैं राहुल बात कर रहा हूँ.
ओ राहुल जोशी, हाँ हाँ, कैसे हैं आप?
सर क्या करूँ, अब बता तो दिया आपको.
But I don't think it's a problem. I don't think you need to worry about it.
My question is, a couple of questions regarding this situation. We never gave any I-134 official affidavit of support.
Yeah, then you are not obliged. Then you are not obliged. No. वो ऐसा होता है.
When the first time visa was applied in 2017, तब सिर्फ एक छोटा सा लेटर दिया था कि we are inviting, them to come and stay with us and all that.
You're not responsible.
134 given.
You're not responsible. I-134 नहीं दिया तो you're not responsible.
The other question I have is, the USCIS, because of this whole coronavirus situation, was allowing kind of, case by case basis, like a little late request of extension. So here in this case, it's only 1 day late. So you see what I'm saying?
I don't know if, that's a good point. You can double check on the USCIS website. I don't think there was an extension.
Because they had announced it.
So you can look at it. I don't remember off the top of my head. I know that there is a dispensation in filing appeals, motions to reopen, responses to RFE. I'm not sure there is any dispensation for
Yeah.
filing an application to extend status late by 1 day. Okay? I don't think there is
yeah, I
any.
mean,
Yeah.
that was case by case.
I don't know the answer to that
But
question. Go
my
on.
main
Do you have anything else for me?
Achha. The main concern I have is the physical address is the same, and that person is staying with us
Well,
in
it is
the same
like I told
physical
you.
address. So
If
that
you,
was my
yeah, that is
real
not your.
headache.
You have to tell the truth whenever and wherever you are asked the question by the government authorities. Tell them whatever the situation is. But I don't think this should affect your H-1B, partly because, like I said, you were not involved in bringing somebody in illegally. They came legally. You didn't do anything. If they want to stay
Right.
here illegally, what
Right.
can you do?
I mean, because we are civilized people, right? हम लोग धक्के मार के तो नहीं निकाल सकते हैं ना. I mean,
Well, civilized,
So,
I don't know about
you asked-
civilized. I think being civilized and being unlawful are two different things. And if somebody's breaking the law, you might invite them to leave. It's just not, I don't know the details. What kind of, see, there are all kinds of crimes and offenses. Some of them are even local instead of federal, harboring illegal aliens, things like that. I don't know exactly what kind of situation would be involved. It has no direct impact on your H-1B, but if there is any ancillary law that affects this situation, I wouldn't know about it. Okay?
Okay.
Good luck to you,
Okay.
sir.
And okay.
All right?
Okay.
All right.
Thank you, sir.
You're
Thank you so
welcome.
much.
Okay, so now this question I have no idea from Wrinkle. How long can a green card holder stay in Canada as a visitor due to medical? So first of all, I don't know anything about Canadian laws. Okay, but when do you lose your green card? If you are gone from United States, even for 1 day, with an intention not to come back, technically you've lost your green card. But as a practical matter, if you're gone for 1 year, you've lost your green card. You've got to do something like a SB1 returning resident permit, convince the government there was a reason why you couldn't come back within a year. If you are gone for less than 6 months, there's usually no problem. If you're gone for more than 6 months, less than a year, they will question you quite closely. So it depends. Trying to read what is the problem. Oh, there's another question. 1 second. Let me just finish this. Yeah, so I told you the law, Wrinkle. The law is stay in Canada more than 6 months. If you do, you'll be questioned very closely. You should have documentation showing the need to stay. If you stay too long, they can take away your green card. So 1 year, they will take away your green card. Less than 6 months is reasonably safe, but more than 6 months is always questioned, and 1 year you lose your green card. Somebody had their hand up at 306, area code 30006. Where are you calling from? 306.
Hi, hello sir, this is Wrinkle. I'm from Canada.
Yes, ma'am.
I'm in Canada right now, and so my husband, I have filed for his green card based
Right.
on the F2A category,
Right.
and we are waiting for our interview to be scheduled.
Right.
Meanwhile, my husband is having a medical condition where he is completely dependent on me for his day-to-day activities.
Right.
So I was in Canada for 4 months last year, and then I went back to US for 3 weeks, and given his condition, I had to come back again. And now I'm close to approaching like 6 months. So it was 4 months, then 3 weeks back in US, and then again close to completing 6 months. And I'm not sure at this point whether my clock starts again with
Okay.
my second trip,
Listen,
or should I
hang on.
consider that since last?
No. This is what you should do, I think. I think you should return to the United States, apply for re-entry
Mhm.
permit, which you just have to be in the USA when the application is filed. Apply for the re-entry
Okay.
permit, asking for 2 years permission to stay away. Once you have filed that, but work with a lawyer because the situation needs a little bit of handling. once you have filed it, you can go back to Canada. You will get an appointment to appear for your biometrics. Come back to USA, do your biometrics, go back to Canada. They will send you your re-entry permit if they approve it, even to the Canadian consulate closest to your house or to any address you give in the United States, including your lawyer's address. So with that, usually what happens is it gives you some amount of assurance that you'll be okay for the next 2 years to stay away.
Okay.
Okay. So I think re-entry permit is the better way to do it.
Thank you very much.
Okay. Good luck.
Okay. Thank you very much.
You're welcome, ma'am. Bye-bye. Okay, so this was a question about number 7, expedite request to process a U.S. spouse's visa. Wife is a lawful permanent resident. We submitted my I-130. It got approved. We have submitted all our documents. My wife is pregnant. She's in USA. I don't have any kind of visa. Yeah, you can ask the NVC for an expedite. They have their procedures. Follow them. Ask for an expedite. What are the chances? It doesn't hurt to ask. I think it's a very legitimate request to want to be in the United States, to have your baby here. Also, you can even try, if this doesn't work, you can even try applying for a tourist visa. They may or may not give it to you, but it doesn't hurt to try, as long as you are being truthful about your situation. Tell them that your green card is pending. Tell them about the pregnancy. You can try getting a tourist visa also. *5. If you have a follow-up question on this, press *5. Okay, let's go on to the next question. Now this is a little bit difficult for me to deal with because you're asking me the mechanics of making an application. Remember, number 1, we cannot assist in filling out forms, and number 2, we cannot provide advice generically. For example, what is same or similar job? That depends upon the job. You look at the job. Partly it is a technical determination and partly it's a legal determination. So I can't tell you what is going to work and what is not going to work. Get yourself a lawyer. I don't recommend doing AC21 portability yourself. I never do. Some things you can do yourself, but not AC21 portability. Better to get a lawyer. I always prefer to join with an H1B even when you have an EAD, because that gives you additional options and additional protection. And I like to be ultra conservative when doing anything with the immigration. Okay. *5 if you have a follow-up question. *5. Okay. Area code 609. That's, I think, New Jersey. Are you calling from New Jersey, sir?
I'm calling from New Jersey.
Yeah, go ahead. What is your question?
Yeah, thank you for answering my question. I have one couple of questions related to this. I mean, after 180 days of verified and approved I-140, I'm joining new company, which I have an offer letter, which I'm joining. Okay. So my only question is, if EB2 goes faster than EB3,
is EB2,
so
sorry?
What should I do? Should I just interfile, or
okay,
if EB2 goes faster than EB3 in future?
Well, you can always interfile.
Oh yeah. After 180 days.
Oh yeah. We've discussed this many times before. Let's say you've downgraded the case to EB3 as a new I-140, and 3 months later, EB2 starts moving faster. You can request the government to put you back into EB2 with just a letter, what you call interfiling.
So that means I have to file from an I-140 again in new company.
No. I'm assuming that you have an EB2, I-140 and PERM approved already. Do you not?
Yeah, that is approved. In the current company, it is approved with more than 180 days approved.
Right.
But if I'm moving to new company after 180 days,
I see.
Then I'm just trying to listen.
You know, I don't think...
Can I use the same EB2 which is...
That's a very good question. I've never run into that situation. I'm not sure you can use... I don't know if you can use EB2 in those circumstances. I have to think this through. don't have enough time to think about this, but it would be, after all, what is AC21? AC21 is attached to a particular I-140, or is it the 485? Once the I-140 is approved, no, you know what? I think you should be able to use EB2 also, because your 485 meets the requirements. Your I-140 is approved and your 485 has been pending 180 days. I am pretty sure, not 100%, but pretty sure that even if you changed employers, you should be able to interfile the EB2 based upon the original 485 filing.
No. Okay, thank you. But what I was saying is, in the current company, I got EB2 already approved,
Right.
and I have applied downgrade to EB3
Right.
Along with the 485.
I got that.
Now I got I-140 EB3 approved.
Right.
Now it is pending for 160 days.
Right.
After 180 days, I'm going to join the new company
Right.
with 485J supplementary form.
Yeah, you're going to repeat the
Now,
same.
after
Look,
joining
listen. I'm 3 steps ahead of what you're thinking. I've already thought through it. So your question is, after 180 days, if I join another company, can I still request EB2 interfiling? And I answered that question. I said, I think you can.
I can. So I don't have to do
Yeah,
again
don't
from
repeat your
form, and
questions.
I don't have to do
I
that.
understand exactly what you are saying. If I don't understand something, I will ask you. So don't repeat your questions. It is, in my mind, because the AC21 requirements are met in relation to both your cases, I think you should be able to use back to EB2 interfiling, even though you are not working with the original sponsor. Okay?
Okay, that's good. Thank you. Only one last question. I'm done with it. The last question is, after 180 days of 45 and after I-145 join new employer, if the current employer revokes my I-140 EB3, will there be any problem for me?
I don't think so. Because once the I-140 has been approved and you have ported off of it, I mean, it's been approved for 180 days, they can't do anything even if they revoke the case.
No, the 180 days is not approved for I-140. I-140 is just approved, but I'm waiting for 180 days of 485.
Now we are talking about
485, not 180 days approved on I-140.
Okay, now we are talking about two different things. There is a set of laws that cover AC21, and there's another set of laws that cover I-140 only. So let's look at the easy one first, which is the AC21 laws. AC21 says if the I-140 is approved and 485 has been pending 180 days, you can port to any job you like, which is same or similar. What does that mean? You filed your I-140 and 485 today. You filed them together. After 150 days, your I-140 got approved. Okay. You have to wait only 30 more days for the 485 to be pending 180 days. Once you have crossed that 180 days and you have used supplement J, even if the I-140 is revoked, even though it was pending for, or it was approved for less than 180 days, you have no problem. AC21 protects you. Why?
Yes.
Because you met two requirements. I-140, yes?
Yeah, two good comments you explained. The second comment I'm very clear. If I filed only I-140 and after 180 days of approved date, that I got it. But what I filed I-140 along with 485 concurrently.
That's exactly,
because I downgraded
sir,
recently.
you're not listening to me. That's exactly what I told you. That's the example I gave you. I said you filed I-140 and 485 together. After 150 days, your I-140 got approved. Now you have to wait only 30 more days for the 485.
30 days of 485. My I-140 is already approved. Implement processing is already approved.
That's the EB2, right? Or EB3?
EB3 is already approved.
If it's
EB3.
already approved,
Because I applied in premium processing is already.
if it's already approved, then you have to still, I gave you an example, not your case. I don't know what your case is. I gave you an example and we are going around in circles now. Did you file I-140 and 485 together?
I-140 EB3 along with 485 together.
So how does that change my example that I gave you? Instead of getting your I-140 approved after 150 days, you got it approved after 50 days. It's the same example. There's no difference. You have to wait for the 485 for
I know
180. It's the same example. There's no
I
difference.
got your example very clearly. I got it very good. Yes, I got it. Thank you. What I was asking is, my I-140 is already approved. I'm only waiting for 180 days of 45, which will be end of this month.
Okay.
After this, I'm moving to new company.
Okay.
My only question was, after moving 180 days of 45, if my employer withdraws my I-140, what will happen to my
I
green
already
card?
told you that question. I answered that question already 3 times. You just are not listening to me because you're
Okay,
so
sorry,
busy.
thank you.
You're so busy framing the question, you're not listening to what I'm saying. I said once you meet those 2 requirements, you are protected by AC21 even if the employer revokes your I-140.
Okay, thank you very much.
Okay. Now, there is a separate set of laws that protect only your I-140. That set of laws says...
Yes, I got it.
Yeah.
I got it.
So that we don't have to worry about that because you're protected by AC21. Okay.
Okay, thank you.
You're welcome. So just to summarize, after you have finished your 180-day waiting period, because your I-140 is already approved, even if the employer revokes your I-140, it does not affect your ability to port and keep porting to different jobs. They cannot touch your green card anymore. Okay?
Thank you very much.
You're welcome. The only exception to this rule is if the I-140 was approved by some grave mistake or fraud or misrepresentation. So the first part, which they call, I'm trying to remember the language of the regulations, but that's really focused more on the I-140 protection, not AC21. Bottom line is, except for very limited circumstances, such as fraud or misrepresentation, your AC21 cannot be touched. Good luck, sir. Okay. Next question, number 9. Rules and restrictions for I-140 upgrade to premium. Employer filed my I-140, downgrade. Priority date became current. Yeah, you should upgrade to premium processing. That's exactly what you should do. Are there any rules and restrictions? No, see, the only rule is, in order for the government to premium your I-140, they must have the original perm. Now, when you first file the case, they don't have the original perm. It's been filed away with the rest of your paperwork. But by the time they issue a receipt, they would have received the file and that would have the original perm. At that point, they can premium your case. So rules or restrictions are simply they need to have the original perm. Okay. Star 5, if you have a follow-up question on this, star 5. All right. Question number 10. I don't know anything about the unemployment compensation for the pandemic exception. See, the way this, I have my doubts about this whole area because there are so many different theories floating around. I wish the government would clarify it. Here is what we do know. When you take ordinary unemployment, not the pandemic one, you are definitely covered and you have no problem with the law. The only problem is, if let's say you're on H1B, you got laid off and you are in New Jersey, and I'm taking an example, I don't know what the laws of New Jersey are. And the New Jersey laws say, in order for you to get unemployment, you must be ready to take up another job. The problem is on H1B, you cannot be ready unless you are sponsored for another H1B. So therefore, technically, New Jersey can deny your unemployment because you're not ready, willing, and able to do another job. That's where the problem comes in. So if the state law allows, you can take the regular unemployment, no question. Can you take the pandemic extension? I have no idea. I think I've explained the question number 1. Question number 2 is, after almost 10 months of unemployment, now I have 4 job offers. On March 15th, you applied for change of status, still pending. Can I initiate multiple change of status? Absolutely. I don't see any problem with it. I think you can. Star 5, if you have a follow-up question on this, star 5. Okay, this is California, I think. California, go ahead, please.
Hi, Rajiv. Namaste. So I have one question related with the second question actually. So I initiated multiple transfers, and the first one I got an RFE. So I was wondering if you do have some data around cases which were on H1B and had to move to B2 and now trying to get back on H1B. Are they applying as change of status, or are they applying as consular processing, and what is the the result around those?
Never apply consular processing. That's giving up the fight without even fighting. Okay, because if you
that's what I did.
Yeah, if you apply for change of status and they deny it, you have the consular option open anyway. So why should you give up a fight without even getting into the fight? You should ask for a change of status. You should say that this is because of extraordinary circumstances. The pandemic has thrown everybody's life into a chaos. You should give me my status right here. So you can ask for it. They can say no, and then you are no worse off than if you had in the first place applied for consular processing. But if you give up without even fighting, what is the point of that? Right?
Yeah, it looks like they are not. I mean, my B2 has been pending for over.
Yeah, yes and no, because in a similar case, not exactly the same case, we actually filed a lawsuit and they settled with us. So, it depends. But right now, because the H1Bs are also open, people are getting vaccinated quite rapidly. I'm not sure I want to spend thousands of dollars fighting it. If I can just as easily go and get a visa stamping. It's a question you'll have to decide as and when the time arrives, ma'am. But I am not inclined to give up a fight without even getting into a fight. Why should I surrender? Ask for change.
Yeah. I mean, visa appointments are also not,
yeah, they're going to be slow.
open everywhere.
They're going to be slow. No question about
Yeah.
it. Oh, by the way, you can also go to a third country. You don't have to go to India. You can go to Mexico, Canada. Mexico is giving visas.
No, I'm a Canadian resident.
Oh, that's
So
even
I'm
easier.
a Canadian resident, but in Canada, they're saying you need emergency appointment. Now, I don't understand what exactly is emergency.
Yeah.
So I sent them email to them, and they said, okay, if your employer says, they gave me few, information based on whatever. There are
They're probably
quite a
talking
lot of
about
stuff in there.
national interest exemption, NIEs. Okay, but that is over because March 31st that expired.
So now I should call them. What do you suggest? Should I call Canadian?
Yeah, why not?
These consulates.
Why not? Why not?
And ask them that can they?
Absolutely. Ask them, say that now this is over. And I think Canada has been rapidly vaccinated as well. They might be coming back to normal pretty quickly. It might be a little while before they can clear their backlog, but it doesn't hurt to ask. Right?
Okay.
Anything?
Yeah, it's a dicey situation. They're not saying no, but they are not giving me a status because they want me to go do the consular processing.
You should also look at Mexico, because I know people who've gone to Mexico and gotten their visa stamp.
But in order to go to Mexico, I need a Mexico's visa to get to Mexico.
I don't practice Mexico.
Right now,
I don't practice Mexico laws. You need to check on it. But my understanding is if you are coming from USA, you don't need a visa to enter Mexico.
Yeah, only if you have a valid US visa, you are allowed to enter Mexico.
People do it all the time when they don't have visas, because that's why they are going to the consulate. So double check on that. I don't know what the rules are, but definitely that's something to look into. All right?
Yeah. All right. Thank you so much.
You're welcome. Good luck, Ji. Okay. Question number 11. Again, unemployment benefits. No clue, guys. U.S. citizen, both my parents are green card holders. Both my parents lost their job due to COVID-19. Father claimed unemployment insurance. Well, first of all, his situation would be different because he's definitely entitled to unemployment. No question about that. And there's no issue of public charge any longer. You can definitely claim that. Right, you're right that it's no longer applied public charge rule. I don't think it should be a problem. You can, if the consulate asks, you can always be a co-sponsor, but don't do it until the consulate asks. The final action date and the date for filing are simply a way of calculating how quickly the government thinks they can move on your case. I think once you submit your documentation back to the NVC, the process is pretty much automatic. Just follow the instructions. Because your family members who are being sponsored are not in the United States, I don't see how the dates of filing helps them directly. Okay, so you should have already received the paperwork from the NVC. Fill that out and send it back to them. *5 if you have a follow-up question on this. *5. Okay. Let's take question number 12. Filing an I-140 and 485 concurrently and I-140 priority date retention. I was in the US, employer applied for 140, approved in 2007, left outside for 6 years, could not apply. My old I-140 is still active. Okay. Can I request my employer to file my I-485? Well, first of all, 485 can only be filed if you are in the United States. It can't be filed when you're outside the United States. So I think what you should do, I don't think you are covered by the quota. Okay. So you can come back to the United States on an H-1B, file an H-1B premium processing. Once you are here and you are working with the sponsoring employer, just file your 485. The dates are current. Go for it. That's what you should do. H-1B and then 485. *5 if you have a follow-up question. Okay. Question number 13, which is H4 EAD. Working on H-1B, my wife is working on H4 EAD. Good till September 2021. We have H1, H4 visas, waiting for GCEAD. Filed for my H1B extension in premium, got the approval. Wife is planning to travel by road to Canada. Use my H1B to extend her I-94. I don't think it can be done like that, sir. Unless she's a Canadian citizen. She has to go through visa stamping to extend her I-94. She cannot use your H1B approval to extend her I-94. No, sir. The only way you can get her extended is through the I-539 process. She can go and get a visa stamp. If she goes and gets a visa stamp, that can be based upon your H-1B approval. And then when she comes back, she will be given I-94 coextensive with the H-1 visa. She won't have to go, or H-4 visa, she won't have to go through 539. But she can't use a hybrid process where she goes to the border, shows your approval, and gets her I-94. I don't think that works. *5 if you have a follow-up question. *5. Okay. So, last question of the day is H4 visa for family of H1B visa holder with I-485 pending. So you are here, family lives in India, they don't have H4. I want to get them a green card. I understand they could move here before my date becomes current. Is consular processing an option if they visit and apply for AOS? Well, these are two different processes. So, first of all, it depends. Do they want to live here and wait for their green cards to come? In that case, you should do 485. If not, they can go through consular processing while you go through adjustment of status. To me, it makes more sense to bring them here and apply for their adjustment of status. So apply for their H4. Okay. *5 if you have a follow-up question on this. *5. Okay. Area code 508. 508, where are you calling from?
Sir, I'm calling from Houston, but my area code is from Massachusetts.
Okay. So tell me, what else can I help you with?
The question is, when you said council processing, so would that be under the family category or the employment category?
You have both choices and maybe even do both. So what happens is, you can file a form I-824 to inform the government. I don't know how your paperwork was filed. Your paperwork may already have been filed as family doing consular processing. If it's not, you can file the 824. What will happen is you will get your green card interview, or if there's no interview, you'll get your green card within the United States. Their files will be moved to National Visa Center, who will then send you a bunch of papers. You will fill them out, send them back. They will move the file to India. Your family will be interviewed for the green card, and this is all through employment-based category. They'll be interviewed for the green card and given the green card through India.
That's helpful. Thank you very much.
You're welcome. Good luck. Okay. So guys, anybody has any questions? I've got, there's another one. 713. 713, where are you calling from?
Yeah, hi. I'm calling from Houston, Texas.
Yes, sir.
Yeah, quick question. My parents entered here on visitor visa in October. They've been coming here for the past 20 years on visitor visa.
Okay.
But this time I filed for their I-130.
Okay.
And it isn't still in recepted status.
Okay.
So it's not approved, but I did receive the receipt, and I filed for their 485 by paper, because that's the only way I can file that.
Okay.
And it's been 2-3 weeks since I sent them. They haven't encashed my check, but their 6 months time will come up on April 23rd or so.
Okay.
So I'm wondering if I have to file for their extension of their visas, or my 485 paper filing 3 weeks ago, is that sufficient?
Do you have proof of delivery of the papers? Did you send it FedEx or some such thing?
Yes, I did send by FedEx
Okay.
to the lockbox.
So did you double check?
Chicago.
Did you double check delivery?
No, I haven't double
Okay.
checked.
So
the
first thing you
delivery.
want to do is double check the delivery. If the papers were not delivered, you should refile the case, the 485. Okay.
Okay.
If the papers were delivered, then it's only a matter of waiting. What I would have you do is double check that you filed the right fees, all the paperwork was properly filled out. If all of that was done, I don't see any point in extending your parents' tourist visa. But if money is not an object and peace of mind is more important, you can go ahead and apply for an extension, even if they don't get it. But above all, remember one thing. Parents of a US citizen, even if they are out of status and unlawfully present for 50 years, they can still get their green card without any problem, as long as they don't travel before they get the green card. So even if they completely went out of status and unlawful, it's not the end of the world. Don't lose sleep over it. But of course, you want to do things right so that the least amount of stress is created, for which I'm suggesting make sure it has been delivered, make sure the paperwork was right, and if you have any doubt, file for an extension and refile the 485 if not delivered.
Sure, yeah. Thanks for that advice. What I also heard is because of the pandemic, they're quite slow at opening paper-based
that is
applications,
true.
and they're almost like 7 or 8 weeks
Yeah,
behind.
that is true. But that's why I'm saying check on delivery. I'm not worried about the processing, but I'm worried about the delivery.
Sure. Thanks for your advice.
You're welcome.
Mr. Rajiv.
Good luck, sir. Okay. I have one more question. Guys, anybody has any question, press *5. But if you have already raised your hand, don't do it twice. It'll put your hand down. So let's go to area code 570. 570, where are you calling from?
Good afternoon, Rajiv. I'm calling from Pennsylvania.
Yes,
So
sir.
this is a new question.
Yes, sir. Go ahead.
Actually, my I-485 is filed in EB2 in October 2020. That time I have not filed any of my medicals. So looking like the dates are moving ahead, my priority date is in March 2011. So I have not got any RFPs for my medicals. In this situation, can I just go to medicals and keep my medicals ready? And can I do like an interfiling without even RFP for the medicals?
Let me
Can I do that?
let me address the question about which I have no idea. The question is, okay, I've got my medicals done. I have no RFE. Can I send my medicals in without an RFE? And the answer, we discussed this yesterday within our own group, our own team, and the consensus of the opinion was that without the RFE, they are not able to connect your filing, your medicals with your 485. So it is better to wait for RFE. But in any case, I did ask our team to look into it further. If I receive any information that contradicts what I think today, which is wait till the RFE, I will post it online on Twitter, LinkedIn, Facebook. So I'll post it everywhere in social media. You can just keep track of it. They are looking into it because I had asked them yesterday to confirm, can I just do my medicals and send them in? Now that's one part. The second part is, now remember that you don't have to do medicals right where you live. So I had cases where in DC metro area it was taking longer to get medicals. So people just went to one of the smaller cities around, a little bit outside DC, and got their medicals done there. And typically medicals, they give you appointment within a day or two. So what is the point of getting them done earlier?
Okay, yeah, that makes sense. But looks like the dates will go very faster. So because all my things are ready, like my 140 is approved and my biometrics is done, everything is done.
Okay.
So I was thinking like to after my green card, so only medical is not there. So
I have another idea. I have another idea for you. How about you go to the doctor and you tell them, look, you can charge me a little bit extra, give me 2 originals. Okay. So what you do is you come home and you send one of the originals out to the government and say, here is my medical. My dates are current. Can you please attach my medical to the 485? And if they lose it, no big deal, because you have another original, which is, I think, good for 1 year.
But somebody told like once the doctor signs, only it's like 2 months is valid.
I think it's 1 year.
I need to send.
I think it's 1 year. Double check, because I think they were keeping it valid for 1 year, not 3 months. Double check it. I don't remember, because the law is, you know what? Now I remember. This is what happens. The medicals have to be signed within 90 days of submission. Right? So it's not that they are invalid from the date of signature. It's invalid because of the limit on submission. You might want to double check on that and then act accordingly. But I don't remember off the top of my head. I know they changed some things around, and you could be right, because it kind of rings a bell that the medicals have to be as recent as 90 days. But they are good for 1 year once they are submitted. Something like that. Okay.
So I think it's like a good, when the doctor signs, it's like 2 months, and then once it's reached to USCIS, it's good for 2 years.
I think, give me 1 second.
Okay.
1 second. I think I have other people waiting in the line. So that is definitely, it's on their website. It tells you what to do. I don't remember exactly.
Okay.
Yeah, just look it up. I'm going to do the same thing. Just look it up. But what we are doing is, we are first going to find out if we can submit medicals even without the RFE. If we can, we'll send them in. At worst, we might have to do it again. Not the end of the world. Okay?
Okay, so if that is good, then I can do like an interfiling.
Why not?
Something like that once you out.
Why not? Well, we are going to find out. I know people are calling. I'll let everybody know. Okay.
All right, Rajiv. Thank you very much.
You're welcome. Good luck, sir. Area code 770, I think, is Atlanta. 770, go ahead.
Yeah, so I just have a question. So, like, you don't have to answer if it takes time. So, after the like 180 days, like if the final action date takes too long for, like maybe for the interview as well, maybe if it takes 5 years or so, like within that time, if I change job maybe once or so if I change the supplement J each time, so like instead of just carry the latest one at the time of interview, so is that legally allowed?
You don't have to bring all your supplement J's. They've already filed them. You are required to only bring the most recent one that you are working at. Okay.
At the time of interview, right?
Yes, sir. And by the way, what I'm hearing is that they are waiving interviews also. So which is what it used to be before Trump came to power. We had very few employment-based interviews. So they might be going back to the same standards again. Okay.
But I can still spend if I know that, okay, I'm going to stay, but later it might change and then again send another one.
You can, definitely. Okay.
Okay. Thank you so much.
Good luck. Next one is, we have 5 or 6 people waiting. Let's see how many we can do. 425. Area code 425. Where are you calling from?
Hi, Mr. Rajiv. I'm calling from California. So I have a question. I'm currently on my last year of STEM OPT and it expires on July 15th.
Okay.
And my case was not picked in the H1B lottery this year. And I'm working full-time currently and I'm looking for options like second masters, and I see that there are universities offering day 1 CPT.
Right.
So could you let me know if this is a viable option, and if in CPTs I know that you have to do internships, so I'm not sure how that works.
Okay, so we've discussed the CPT issue many times. What I would recommend is go to our frequently asked questions or immigration.com. You should be able to see at least 6 or 7 discussions on this. Bottom line is this: CPT can work if I would like the university to be accredited, number 1. Number 2, I would like them it has to be a graduate program to give you day 1 CPT. Number 3, their online material or printed material should clearly show that practical work is required to earn the degree. Otherwise, you can't get the degree. And lastly, whichever employer you choose to go with, the university should give you a letter to get it signed from the employer, which says, I, the employer, understand that she's getting her credits for this work. I'll make sure she works only in her area of study. So if you are doing a master's degree in marketing, you will only work in marketing. If you're doing a master's degree in information systems, you will only work in information systems. So these 3-4 requirements have to be met. USCIS doesn't like CPTs, but I really don't care. My job is not to be popular with the USCIS. As long as it is legal, I would do it. They've been denying status to people. So how does that matter? I don't think it's the end of the world. If you apply for an H1B while you were on CPT, they can say, okay, here is your H1, but go outside, get visa stamping. So big deal. Go get visa stamping. So CPT can work. That's the bottom line. Okay.
Okay. So day 1, if my employer agrees and if my university curriculum shows practical training is required, I can work day 1.
Yes, ma'am. You can. Okay.
Thank you so much.
You're welcome. Good luck.
Thank you.
All right. Bye-bye.
Thank you so much.
You're welcome. Maryland, area code 301. Go ahead, please, Maryland.
Hello, Rajiv. So this is Jordan here, and thank you for your services for the community. I'm beneficiary of the I-130 as well as the I-140. My I-130 is approved for my brother in 2010, and my I-140 is approved in 2016. So recently, we are aware of that spillover happens. So they have shifted the family-based green card to the employment-based category, considering that they are unused and they cannot process out of the United States. because of the pandemic. But I'm present in the United States. Is it possible that I can file my 485 adjustment status
Okay,
on the
hang
basis of the
on,
brother and
hang
sister
on.
category?
Let me get this straight. First of all, were you applied for directly or are you coming through your parents?
No, my brother applied. My parents are green card holder. My brother is a US citizen and he applied for my I-130, which is approved in 2010.
Okay. So it should be coming due in about a year or two. So let me put it to you this way. If your I-130 is approved and your date becomes current, you can file 485 here in the United States if you are here legally. Okay.
No, but the thing is that, I mean, if the spillover, they are considering, I mean, I'm concerned about the spillover, right? Can we challenge the spillover thing? I mean, based on the considering that I'm still here and, I mean, it will be the same for me, like considering the employment-based category or the, I mean, family-based category.
So what you are saying is beginning October 1st, all those leftover family-based visas are going to go into employment-based. Can we challenge that? The answer is no. That's the law.
Right. We cannot challenge
No,
that,
sir.
right?
I do not know of any way you can challenge that.
Okay.
It's a part of the statute. Congress made the law.
Okay.
Okay.
Oh, okay.
Good luck.
Okay. Thank you.
One second. Yeah, Rahul, you are the last question. Go ahead.
I have a follow-up question, Rajivji, regarding what we already talked about.
Okay.
So in general, is this situation, because when that person goes back, is this situation going to create problems for us in the future with others? Benefits like adjustment of status and all that?
I don't think so. See, unless you are actively involved in some kind of fraud, I don't see how this affects you. How can you control somebody else? Okay.
And then the other question I have
I'm gonna have to put you on hold. I've got one more caller. Wait.
Sure.
Okay, they just hung up. Okay, make it really quick. I've got to go. Make it really quick, and I'll give you a few more seconds. Go ahead.
Sure. I noticed that there is a DHS website to report immigration violations. So if I do that, would that basically clean my own case?
I don't know the answer. I don't know the answer to that question because I don't think there is anything to clean up anyway. Okay? Good luck. I gotta go. Go. I can't spend any more time with you. Sorry.
Thank you, sir. Have a very good day.
You too. 703. Go ahead. Last question of the day.
Hi, Rajiv. I'm from DC Metro. Just a quick question. H1B and I-140 approved with employer A and you're with employer B. If you come back to employer A again, do you need to refile the GC process again? Like for I-140?
That's not a brief answer. Okay. I have dealt with this situation several times before. Go consult the frequently asked questions. I'll give you the short version. When somebody leaves an employer, there is a doubt whether the job was discontinued, whether the job ceased to exist. If the job did not cease to exist, let's say your job was a database administrator. You left after the I-140 approval, and after you left, somebody else took the job, or two people are sharing the same job. That means the job did not cease to exist. You can come back. You don't have to do anything all over again. Okay. But what if the job ceased to exist? If you were the only database administrator, they never hired anybody else. They just put everything on the cloud, or they used a hosted service and they stopped using a database administrator. Then there is some doubt whether the green card continued or not, and you have to refile. So not an easy question to answer. Talk with your lawyers. Chances are you will be okay without having to refile everything.
Fine. Thank you.
You're welcome. Good luck. Hey, you guys. Sorry I got to run, but it's always a pleasure to talk to all of you. In 2 weeks, we will talk again. Bye-bye.